Charlie and Donna Adelson. Rashbaum represented both. The conflict was ignored. Rashbaum handled Charlie's trial. Now Charlie says the conflict prejudiced him. Will Charlie prevail? Prof Jo thinks no. Rashbaum withdrew from Donna's case. She found new lawyers. Donna says her rights were violated because she lost the lawyer of her choice. Will Donna prevail? Prof Jo says no. So ciao a tutti, and hello to you proffers out there. I am Prof Jo, professor of law, and this is Prof Jo Explains. As most of you know, it has been a long and torturous road to bring to justice the perpetrators of the murder for hire of Florida State University law professor Dan Markel. Today, I want to tackle one of the most complicated aspects of the case, at least to explain, so bear with me on this. This is a matter that may impact the October 2023 murder conviction of Charlie Adelson. And it's an issue that led to almost a year's delay in Donna Adelson's trial and may impact her murder conviction. Before I begin, for those of you who may not know this case, and I'm sure there are a few of you that don't, and for the others, we know it, but it's not so terrible to listen to the facts again. I'm going to do a quick overview, and I've got two slides, one that lists all the perpetrators and the other that gives you pictures of them and gives you a little different way of looking at them. So it was a July 2014 murder for hire. Dan Markel was a law professor at Florida State University in Tallahassee. He was married to and then divorced from Wendy Adelson. Wendy and her mother, Donna, wanted Wendy and the two boys back in Miami, where Donna, father Harvey, and brother Charlie lived, and Daniel Markel was in the way. Charlie knew someone, Catherine Magbanawa, who knew someone, Secretive Garcia, who knew someone, Luis Rivera. Garcia was the trigger man, Rivera drove the car, Magbanawa was the go-between. Charlie and Donna paid for the hit. Every one of them was convicted of murder. Charlie in 2023, and his case is on appeal. Donna in September 2025, and she's in the process of doing her appeal. Before any of the murder trials, all of them, any of them, Donna and Harvey had a lawyer in Miami, Daniel Rashbaum, and he handled their business matters. When Charlie was indicted, Rashbaum switched from representing Donna and Harvey to representing Charlie. That seems a little odd, but the business affairs were very different from the criminal case involving Charlie. And Rashbaum said he had waivers from everybody. Then Charlie was convicted and Donna was indicted. Rashbaum then switched from representing Charlie to representing Donna. He said he had written waivers from both of them. This seemed very strange. Lawyers looked at it and raised their eyebrows up into the top of their foreheads about it. It was very strange and it was very risky. Donna clearly wanted Daniel Rashbaum to represent her. They had a very close relationship. Daniel Rashbaum described it as almost mother-son, which, by the way, is another reason why you should have stayed away from representing her. You shouldn't be representing people in your family. It's too close a relationship. You risk not being objective, and a lawyer needs to be objective in looking at the evidence and proceeding. But Donna Charlie wanted it. Donna wanted it and said so in open court twice before the day her trial was scheduled to go. But ultimately, Charlie prevented it. So let me look at Charlie's side of this issue with regard to Daniel Rashbaum. As I said, Charlie is appealing his criminal conviction, not on the conflict issue, on other things. He's appealing his criminal conviction, and I say, sorry, Charlie. I fully expect his conviction to stand on the grounds that he's raising on appeal. But he could not raise his lawyer's conflict. In other words, representing him then and what that meant. He couldn't raise it on appeal because the only things you can raise on appeal are things that actually happened at trial. Evidentiary rulings by the judge, statements by the defense or prosecutor, things you did or didn't do. The conflict of interest of your lawyer is not something that happened in the transcript of the trial, in any of the record of the trial. You can't raise it on appeal. What you have to do with that issue is you have to make what's called a collateral attack. What that means is after your appeals are done, you appeal to the appellate court in Florida, and the appellate court affirms your conviction. Then you have a right to ask the Florida Supreme Court to take a look. The Florida Supreme Court takes a look and says, conviction affirmed, or the Florida Supreme Court says, hey, we're not even going to take a look. Again, your case is now over. Your appeal route has ended with the Supreme Court. Nothing more you can do. Now what you're going to do on a collateral attack is coming this way. Excuse me. You're going to start here and raise it at the trial level. And the effect of that is, since it's at the trial level, if you need a hearing, if you need to call witnesses to support the claim, you can do that at the trial level. That's not something an appellate court can do. It's not something a Supreme Court can do. So Charlie is now going to raise, if as I fully expect, his convictions are affirmed on appeal, he's going to raise the conflict of interest of his lawyer in a collateral attack. The collateral attack or the conflict issue really comes under the Sixth Amendment right to a fair trial. The Sixth Amendment right to a fair trial says you have the right to hire whomever you please to represent you. But it also says that you have a right to the effective assistance of a lawyer. So it's not enough you have a lawyer to represent you who sits in the trial court and sleeps through the whole trial. So your lawyer has to provide effective representation to meet the Sixth Amendment right to a lawyer. And if your lawyer has a conflict that means that he cannot represent you fully and zealously, then it's like you didn't have a lawyer at the trial to begin with. So that's the area in which Charlie is operating. So now let's look at Donna's case. Donna, on the very day the jury voir dire was to begin at her trial, in other words, the day that they started selecting a jury, before they even started, the day that they were supposed to start electing a jury, the conflict of interest exploded. At the end of the day, Daniel Roshbaum withdrew from representing Donna at her criminal trial. A few days after that, Judge Stephen Everett barred Donna's co-counsel, Alex Morris, from representing her, and also the so-called conflict-free lawyer that they had added, Adam Comazar, who had just been hired to try to resolve the conflict issue. He was also barred from representing Donna. She had to go out and hire 2 new lawyers to represent her. She may claim on her appeal that her Sixth Amendment right to the lawyer of her choice was violated. So I have gone over now several videos looking at Donna's claims on appeal or potential claims on appeal, and you can find them at Prof Jo Explains. Today, I want to go over the conflict issue related both to Donna and to Charlie. The Sixth Amendment gives a defendant a right to a fair trial. It does not give a defendant a right to a perfect trial. We don't get perfect in this world. If you had a right to a perfect trial, all we'd ever be doing is going up and down, trial ends, appeal, new trial, appeal, new trial, appeal. So you don't get a new trial for every error that may have occurred at trial, because there are going to be errors made at trial. The Sixth Amendment right gives the defendant, as I said a moment ago, a right to the effective assistance of a lawyer, and also the right to hire a lawyer of your choice. But both rights are fundamental. I have taught this subject, the Sixth Amendment right, the effective assistance of counsel, maybe to thousands of law students over the years, to practicing lawyers, and to judges. And I think I actually do a pretty good job of explaining this stuff. But traveling through the issues in this case and how it got to where it got is going to put me to the test. So at the end of this video, I'd love for you to give me a grade and tell me how I did. You can't hurt my feelings if you think I didn't do well enough. You'll probably just give me an incentive to do better and to figure out how I can make things more clear the next time around. So you can give a grade, ask a question about the law or today's case at xprofjo@gmail.com. You can give me a grade here on the YouTube channel, or drop a question or a comment. You can also follow me on Prof Jo Explains It on Facebook or wherever you look at your podcasts. And if you subscribe, and as I've said before, please subscribe. You'll never miss a live episode. And if you like, then please indeed hit like. And if you like ad-free, and who doesn't, you can find me and sign up on my Patreon page, where we do some exclusive content and where we will have some live meet and greets, Q&As, and other kinds of things that I think for those of you who are interested in the trials and legal issues, and I think you wouldn't be here if you didn't, then I urge you to consider my Patreon page. And finally, Prof Jo Explains Facebook group is out there. So lots and lots of ways to connect. So now let's begin here. A lawyer has a duty of loyalty to a client and to represent that client zealously. It doesn't mean the lawyer can cheat, but it does mean that the lawyer has to do her best job at representing a client. A part of that is, it's not likely that a lawyer can represent two clients at the same time with regard to the same matter, because there's always a potential for a conflict. What's in the best interest of one may not be in the best interest of the other. So the legal system, the rules of professional responsibility, look askance at a lawyer who is going to be representing two clients, and the lawyer has to demonstrate in some way that the conflict is not going to affect the representation of either of the clients. So one thing the lawyer has to do is to disclose the conflict to both of the clients. Now here, Donna and Charlie obviously know that Daniel Rashbaum planned to represent both of them. And Daniel Rashbaum needed to sit down with them and explain the potential that a conflict could arise. Better to have somebody other than he explain that the conflict could arise, because he's got an interest, and a judge later may wonder if he fairly and adequately and completely explained the conflict. Now, I'm not going to claim that Daniel Rashbaum didn't do that here. There's no reason to believe he didn't, but it's still better practice to have somebody else do it. And the lawyer also has to get a waiver from each, in this case, from each of the clients. The waiver needs to be either in open court or in writing to meet the requirements of law, to be an effective waiver. Some lawyer conflicts just are not waivable, period. Doesn't matter what the client wants, you can't waive them. And in addition, even if a client waives, he can always change his mind. So it's kind of a little ticking time bomb. You know, there's a conflict there. The client says, no, I'm not worried about it. Go ahead. But it's ticking. And at any point that client decides, now I'm worried, the whole thing blows up and falls apart. So that's some kind of background on where we're going here. At the start of all this, Donna and Charlie obviously were on the same page. There was no reason to believe one of them would turn on the other. Their mother and son, they're involved in the same criminal enterprise. It doesn't appear that one's defense is going to be different than the other's. So no reason to believe it might occur. If you recall, and I think most of you will have some memory of this, Rashbaum had this secret defense for Charlie that he was going to raise at the trial, and he didn't want anybody to know about it. And even in his opening statement, he didn't disclose the full extent of this secret defense. Why? Because he didn't want the prosecutors to get a head up and maybe be able to find evidence or think about arguments they could make to confront it. As an aside, that was a bad idea. The earlier that you give the jury a picture of what your case is going to be like, the better off you are. Because evidence comes in every which way, no witness. You try to do it in chronological order, but it's impossible. One witness is going to be able to give evidence about a couple of things. You just can't be purely chronological. Plus, at the beginning of the trial, the jury knows nothing. And if you don't give them a clear roadmap, they're hearing a lot of things and they don't know where the things fit. Better to let them know. But his idea was better to keep it a secret because then the prosecutor couldn't prepare ahead of time. As we found out, this great secret defense was this silly extortion claim. I say silly. I stand by silly. I don't know a lawyer out there who said anything else but silly. They may have been a little more polite about it. They may have been a little more elevated in language in describing it, but it was silly. And let me say a little about it. Charlie had to account for the fact that the money that was paid to Garcia and to Rivera and to Magbanua was stapled. At least one of them testified to that. Maybe two did, but at least one testified to it. People don't normally staple money. Apparently, Charlie kept his money by taking $100 bills. When he had 10 of them, he'd staple them together, and then he'd have 1,000 together. A lot of us don't have that much cash around to be able to do that, but I don't know anybody who staples money as their way of keeping it straight, and I bet you don't either. So he had to account for the stapled money. That kind of limited what his defense could be. And so this defense they came up with was Garcia and Sigfredo, yes, they killed Dan Markel. They did the murder, no question. And yes, Charlie paid the money, but the money was not paid for the murder. No, what happened was these two men in Miami, one of whom was a gang member, both of them used drugs. None of them had a, long-standing permanent job. They went from woman to woman and job to job and, were on drugs. These two guys in Miami, who, as far as we know, never got far from Miami, had heard from Magbanua that there was this dentist in Miami. And he kept money in his house. And he was unhappy with his brother-in-law. And so they decided to drive 8 hours from Miami to Tallahassee to kill his brother-in-law. And mind you, Charlie was dating the woman, Catherine Magbanua, who Sigfredo had an on-again, off-again relationship with, and they had 2 children together. And he was jealous of the fact that Catherine Magbanua was now seeing Charlie Adelson. Nonetheless, this person, these 2 guys in Miami, drive to Tallahassee to kill Dan Markel, something that Charlie would have been happy with. And they're doing it for somebody that Sigfredo doesn't like, to say the least. And the idea was then they would extort him and he'd have to pay them. Otherwise, they would go to the police and say he hired the murder. Now, if that doesn't sound silly to you, I don't know. It sounds pretty silly to me. And in fact, Luis Rivera said, well, if he's got the money, why don't we just go to his house and rob him? Why do we have to drive 8 hours somewhere else and commit a murder to get the money? Which is not a bad question, one might say. But anyway, this was the defense. Daniel Rashbaum thought this was going to be a winner. Charlie thought it was a great defense. And from all we know, both of them were shocked when the jury at his trial came in maybe 2.5 hours, and they stopped for lunch, by the way, with convictions on all counts. Both of them were surprised because they thought that was just a great defense. Anyway, that's the secret defense that Daniel Rashbaum did not want the state to know about, because then they might be able to do something to effectively confront this defense. Daniel Rashbaum added to the defense team Alex Morris, who is a local Tallahassee lawyer, and from all reports, a pretty good lawyer. And so he added him to help, Rashbaum added him to help him defend in Donna's trial. By this time, Charlie's convicted. Rashbaum's now moved over to Donna's trial. Because of the potential conflict, because Alex Morris looked at it and said, you've already represented Charlie. This looks like a conflict to me. I want what they used to call a Chinese wall. I do not want to hear anything at all, nothing about your representation of Charlie, because that's your conflict. I want to be completely free of it in case Charlie testifies, when it would looks like impossible for you, Daniel Rashbaum, to cross-examine him because he was your client before. And how are you going to demonstrate that your cross-examination is completely unrelated to anything he may have said to you in a lawyer-client relationship? I need to be walled off so I can come in and do the defense. So that's what Alex Morris said he did. And in fact, later when all this erupts, Judge Everett has an in-camera interview with Alex Morris, and initially concludes, you're right, you did wall it off. You could represent her if Daniel Rashbaum is no longer on the case. So he did a good job, evidently, of walling himself off. That's where we were. He never looked at any documents. He never talked to Daniel Rashbaum about the defense of Charlie, nothing. They did not expect Donna to testify at Charlie's trial. And again, same problem. It wouldn't have erupted then because at Charlie's trial, Rashbaum had not yet switched over to defend Donna. Her trial was coming later. But there was a potential, if he cross-examined Donna, then how could he represent her if she then was charged? That was the looming issue there. So they never intended to call Donna or Harvey. And they didn't think it was going to be an issue. They didn't think the state was going to call her either. No issue. Their interests were the same. They're not going to rat on each other. They've got the same defense. And we can manage all this. And if there does have to be a cross-examination, moving back to Donna's trial of Charlie, and no reason to believe Charlie would testify at Donna's trial for the state, Alex Morris can handle it. Everything is copacetic. Okay, that's where the thing sat. Charlie was convicted. He appealed. His attorneys on appeal start talking to him about the conflict of interest issue and whether he's got a claim there that might lead to a reversal of his conviction. So on September 11, 2024, this is before Donna's trial was going to start, the state issued a subpoena to Charlie to testify at Donna's trial. His appellate lawyers met with him and said, now we really do have a problem. This was September 14. On September 15, they filed a notice that Charlie would not waive his conflict of interest running from Daniel Rashbaum representing him and now representing his mother. The trial was supposed to start on December 17th. That's what I said. That was the day when the jury voir dire was going to start, when they were going to start picking a jury. So I want to play a clip now of what happened right at the start. Laura Niles is one of Charlie's appellate lawyers, and she's the woman that you're going to hear talking at the start. You're going to hear her, and then you're going to hear Alex Morris talk on this clip. So this is clip 1 that we're going to be listening to.
Come on up. You can stand at the lectern if you wish.
For the record, Laurel Niles, on behalf of state witness Charlie Adelson.
All other counsel of record can make their appearances at this point.
Georgia Kappelman for the state.
Alex Morris on behalf of Mrs. Adelson.
Dan Rashbaum on behalf of Mrs. Adelson, who's present.
So, how was everyone's evening last night?
Got a lot of sleep, Your Honor. How about you?
Slept like a baby. Let's start with the notice of invoking rights and non-waiver of conflict of interest by Mr. Adelson. Do you have anything to argue beyond what's in the pleading?
Your Honor, I'm not here to advocate for a position for the court to do something in this case. The only thing I intended to do with my filing is to invoke Mr. Adelson's rights, to put the parties in the court on notice that he does intend to invoke his rights.
Right. Ms. Kappelman, does the state have a position that it wishes to raise concerning the notice or the filing?
My only position, Judge, is that this issue has been waived. Your Honor did an inquiry which was thorough, covered the issue, and...
As to Mrs. Adelson.
Yes, sir.
Concerning Charlie Adelson, I believe, well, I don't want to get ahead of myself, but the only way Mr. Rauschbaum's representation could occur is if both ends of the conflict were waiving. I don't believe Mr. Adelson ever took an affirmative position one way or another.
My understanding was he did, but I guess that position is changing, so I don't know. I have to defer to Your Honor on that.
Does the state intend to call Charles Adelson as a part of its case in chief?
No, he would be a rebuttal witness at this point. Now, that could also change too, but as of this moment, he is a rebuttal witness.
Ms. Niles, is there a reason that your client waited until yesterday to assert his invocation of this right and non-waiver?
Your Honor, I think the critical question is when the conflict arose. So...
Oh, the conflict has been there. The conflict is clear on its face. It's as clear as my nose. Is there a reason your client did not assert this until yesterday?
Your Honor, my understanding is that my client has not waived at any point. And so asserting it yesterday was merely putting the parties on notice of that non-waiver. I mean, the fact that he's listed in discovery as a Category A witness does not mean that the state was going to call him as a witness at trial. I think the conflict arose when my office received a subpoena for his trial testimony, which was last week on September 11th, and then he was transported to the jail on September 13th. Mr. Efferman was able to meet with him at 8 o'clock in the morning on Saturday the 14th. And then at that point, without revealing any confidential communications with our client, we became aware that all the parties needed to be on notice that there was no waiver and that he does intend to invoke his rights. And so our notice was filed the next business day, Monday morning. It was later in the morning, but we were trying to get it done. We were a non-party, so we were having some trouble figuring out how to get it filed, but we drafted it and alerted the parties and the court as soon as we knew that this was an imminent issue, that his rights were imminently potentially going to be violated. Now, I don't think, excuse me, I don't believe they would be violated until he takes the witness stand, and at that point, either his former counsel attempts to cross-examine him, or another member of the defense team attempts to cross-examine him, or they advance an interest that is materially adverse to his interest. So I think the potential for conflict was always there. But the conflict arose, it's going to arise on the witness stand. It has not quite yet arisen. But the potential for conflict.
It's simmering, not boiling.
Yes, Your Honor, it's burgeoning.
Mr. Morris.
Yes, sir. Judge, when I came into the case, at the inception of the case, obviously I was aware of the fact that Mr. Ashbaum had represented Mr. Adelson. I was aware of the conflict. Whether it's arisen or not, my view of it is that it's always been there and been present. As a result of that, I have been walled off from everything as it relates to any discovery from that prior case, any notes. I've not had any conversations with Mr. Ashbaum about Mr. Adelson's evidence or property. The first instance that I met Mr. Adelson was this past weekend on Saturday with Mr. Ufferman. And in fact, Mr. Adelson queried whether or not I had seen his phone. I said, no. But we planned for this exact circumstance. And the idea was that I was going to conduct any cross-examination if Mr. Adelson were to testify. Mr. Ufferman's motion argues to impute the conflict absent a showing, a good faith showing of an ethical wall. I think that we've done that, but of course, as I mentioned in my response, we planned in the alternative, if we're forced in that direction, of securing alternate counsel.
When was the third-party counsel retained?
Candidly, there's been no retention in terms of money from Mrs. Adelson to that lawyer. That's prepared to happen. We wanted to see Your Honor's ruling. But the answer is I spoke with the attorney yesterday to confirm, just as I mentioned in the response, availability and absence of conflict for that lawyer.
All right. I've gone through, I believe, at least 2 Lazarlet inquiries with your client, specifically as to this conflict that exists between his former client, Mr. Adelson, and his current client, Mrs. Adelson. Is there a reason the defense did not bring before the court that you were pursuing third-party counsel, or there was, in fact, no waiver from Charles Adelson?
Well, let me back up and provide the court some information then. So there was, in fact, a waiver with Mr. Ashbaum. Mr. Ashbaum consulted.
Verbal or written?
Both. There was a third-party lawyer, Mr. Moses, who was hired as third-party counsel out of South Florida to consult with Mr. Adelson independently outside of Mr. Ashbaum's presence. And as it relates to the waiver, my understanding is that the waiver was agreed to. I believe it's going to be verbal, Judge, in the sense of not in writing. The written portion of it is the lawyer who consulted with Mr. Adelson. That was because of security issues, is the way that was dealt with. It was post-conviction. The Department of Corrections housed Mr. Adelson closely managed, and as a result, there was an inability.
Okay, so you can hear how this all started. At this point, you can hear Alex Morris, or you heard Alex Morris say that they retained or are in the process, we're in the process of retaining yet another lawyer. Remember, he'd been walled off, and so he had no familiarity or contact with any of the evidence that was in Charlie's trial. But they have now hired yet another lawyer who not only didn't have any contact with it, but has not done anything with the case in order to come in, and they're calling him conflict-free. They still think that this can be resolved by having now this third lawyer do the cross-examination of Donna. And Donna still wants Daniel Rashbaum to be able to do the trial. So they think this is going to work, but now we're going to hear what the appellate lawyer, Lauren Niles, has to say about this. And she's going to get very technical. She's going to be citing 2 different rules of professional responsibility. The real issue is, on the one hand, can you fix the problem if Daniel Rashbaum, if Charlie Adelson testifies at Donna's trial by having somebody who's conflict-free handle a cross-examination? And remember, they don't think this is going to happen. They don't think Charlie is ever going to testify anyway. The state said only on rebuttal, probably, if at all. But they think it can be handled this way. This is the way they felt at the beginning. Now they've hired yet another lawyer to be conflict-free to do it. But now you're going to hear what Laura Niles, the appellate lawyer, has to say about this. And this is clip 2.
Not wanting Mr. Rashbaum, or potentially by extension myself, to cross-examine. And that was the limit of the conflict, is my understanding.
Ms. Niles, do you need to clarify anything?
I do need to clarify that, Your Honor. Our first filing yesterday, the notice, did frame the issue in terms of concern about potential sharing of information on the defense team, right? Mr. Adelson was not waiving his privileged communications with Mr. Rashbaum. But after we read the response from counsel, I think it became clear, based on our reading of the rules regulating the Florida bar, that it would not be enough to bring in a third party, or it would not be enough to have a walled-off attorney conduct the cross-examination. And that's because I read Rule 4-1.9A to control on that issue. So Rule 4-1.9B says you can't use information gleaned from the representation to the disadvantage of a former client, but A says you cannot advance an interest that is materially adverse to a former client in the same or substantially related matter. So whether we have another attorney come in and do that cross-examination, and I absolutely trust Mr. Morris, and I'm not challenging his veracity when he says he was walled off from this issue, but I don't think it solves the problem, because whether we have another lawyer actually conduct the cross-examination doesn't solve the issue of A under that rule. In the case cited in Mr. Adelson's notice called Colker that Your Honor just referenced, also addresses this exact issue and says having a third party conduct the cross doesn't resolve the conflict, because it's the relationship that forms the basis of the conflict, not just the information. So it would be our position that Mr. Rashbaum cannot advance an interest against Mr. Adelson. Because Mr. Adelson is now going to be a witness for the state of Florida, that is a problem under the rules regulating the Florida bar and Florida case law.
Well, does any party have anything further they wish to add to this matter?
Brief response, Judge. Of course, Ms. Adelson has a right to counsel of her choice. I recognize that there
it is not absolute.
Understood. I recognize that there are restrictions, but in the circumstance that's before us, then Mr. Adelson may not testify in this case. And that's a little bit of the frustrating part, is that this can be utilized as a tactic in some respects.
It doesn't mean he still can't lob a hand grenade in the direction of the trial.
Sure. Understood. The frustrating part, I guess, is that the defense doesn't intend to call him. The state's acknowledged that it would be in rebuttal if they were to call him. And I can't fathom why there would be a lot of direct or cross-examination. But
if this witness cannot be properly cross-examined, your client has lost the right to effective representation, and therefore we have an issue relating to whether or not a new trial is merited. At the outset, it is foolish to charge forward under the circumstances. I can examine your client if she's willing to waive the issue of the conflict and also waive the issue on appeal. That still does not per se resolve the matter. Do you wish for me to examine your client?
may I have just a moment, Judge?
Go ahead.
So, appellate lawyer says it's not going to be enough because the relationship, that is the lawyer-client relationship between Charlie and Rashbaum, when Rashbaum was representing Charlie, is the problem here. And you don't get around it by saying the issue is the isolated issue of the cross-examination. You also heard some discussion of, was there a waiver or not? The appellate lawyers say Charlie is saying he never waived. Clearly, the defense didn't get a waiver in writing, which is the requirement under the rule. And now, assuming they were going to go forward, you would have the issue of did Charlie waive or he didn't waive, and they're going to have to bring in that second lawyer who they call just to inform him of his rights to do it. So it's already getting pretty messy. So at this point, the judge now is going to inquire of Donna whether she's willing to waive her right to have an effective cross-examination of Charlie if he testifies. And we're going to listen to another clip. Donna makes one of the more incredible statements I've ever heard a defendant make on the record in any criminal trial. And it's just illustrative of how much she wants Daniel Rashbaum to be her lawyer. So what they did was to, I think there's a recess now where the conflict-free lawyer, Adam Commissar, talks to Donna and explains her rights to her. And then they're going to come back on the record. We're going to hear this clip. And you're also going to listen for it, that the new lawyer is going to do a CYA here before this is done. So we'll listen to clip 3 now.
Please, the court, just for your awareness, I've been involved in this since yesterday.
That's Commissar.
She has had a chance.
Welcome.
She has had a chance to speak with me. She's in a position where she would not like to lose Mr. Rashbaum. She's willing to make any waivers that are necessary. She's not seeking a continuance, and she's fine with currently unprepared counsel conducting the cross-examination of Mr. Adelson should he be called.
Well, let's go ahead and finish the colloquy that we started earlier concerning the waivers. Ms. Adelson, if you can stand once again, you have already been sworn. Now that you've had the opportunity to discuss with Mr. Commissar the issues that are related to the conflict of Mr. Rashbaum, and also any issues as it would relate to proceeding forward under these circumstances, are you in fact waiving any conflicts regarding Mr. Rashbaum?
Yes, sir.
Do you also waive any issue on a future appeal regarding the issue of your son's cross-examination, as it pertains both to the preparation of any counsel who would perform that cross-examination, or the fact that it may not be adequate representation?
Yes.
You may be seated.
Incredible.
Does the state have anything to raise concerning this matter at this point?
Just that the state is in agreement with proceeding as outlined by defense counsel. In the limited research I was able to do on the issue, it seems like a lot of the times when it goes the other way and the court in its discretion decides to boot the counsel of record for conflict, the state is seeking that. So I just want to put on the record that we are not seeking for Your Honor to do that in this situation.
To dismiss Mr. Rashbaum?
Correct.
Very well. I'm going to perform my additional research before we continue this afternoon concerning whether or not this waiver is sufficient. The defendant has made it. She has made it voluntarily. At the same time, whether it is sufficient to survive any review, that is really where my mindset is at this point. Unless any other party has something to raise, we'll be in recess and get started again at 1:30.
Judge, As Ms. Niles, in speaking with her during the break, is she and Mr. Upperman are meeting with Mr. Adelson, because the question has arisen as to whether or not there's a conflict as it relates to cross-examination, or if Mr. Adelson were to have a continued objection to his continued representation of Ms. Adelson. I think that there's some thought that that needs to be confirmed from Mr. Adelson first, because if he takes a different position, it would seemingly disqualify Mr. Rashbaum altogether. That's going to be accomplished. I wanted to let the court know that that's in the works.
Good.
Also, as it relates to the waiver, so the court was aware, and there's mention of it in the comment section of the rules regulating the profession, that an oral waiver is acceptable and appropriate with certain conditions that are set forth in the rule.
Is the attorney who obtained the waiver available to speak on this matter?
I don't know the answer off the top of my head, but I'm pretty certain, I say within 99% certainty, we'll facilitate it.
Go ahead.
Does Your Honor need, that's why I'm mentioning this, should I, excuse me, Judge.
The signature was obtained by me, and then the independent waiver did not get a signature, but he could testify as an independent waiver.
Does Your Honor feel like you need to hear from him?
So we have a fully developed record? Yes.
Okay, let me make arrangements during the break, and I'll alert Chambers as to how quickly we can do that, so we don't waste time this afternoon if possible.
Please do.
Yes, sir.
I'm going to have the afternoon jurors report at 2 o'clock, so that way no one's time is wasted while we're going through these matters. Mr. Commissar, you had something else to add?
Here comes the
Your Honor,
CYA.
As we're talking about perfecting a record, I just wanted to note that as the independent counsel, I was given an opportunity by the court to meet with her independently. The bailiffs gave us some privacy here. I was able to meet with her for easily 30 minutes. And I'm not revealing any of our confidences, but this was not a squishy situation. Once I was able to articulate the options and how they can result in delay or the opportunity to prepare, this, I can say, was a strategy decision that is being made by a defendant who does not want to delay their case, but understands that the representation they're going to get from my cross-examination is not what they might get from another lawyer, or definitely not what they're going to get from me with a year of preparation. So it may look odd in a cold record having a lawyer come in this morning and advise somebody to waive such an important right. I was able to articulate the options, but I did not necessarily advise somebody to waive their rights.
Very well. Mr. Morris, do you wish the court to engage in any further colloquy with Ms. Adelson concerning this matter?
Not at this point, Judge.
Okay, so you heard the conflict-free lawyer putting on the record that he told her everything and she wants to go forward. And the incredible nature of her saying, I understand that this means that my son may testify against me and I can't have a lawyer effectively cross-examine him. It just boggles the mind. Now, I assume that what she was told is, one, it's extraordinarily unlikely that Charlie will testify. And two, it's very unlikely that he'll say anything to your detriment. But nonetheless, it's still extraordinary. So at this point, it's still up in the air because the appellate lawyer suggested that the attorney-client relationship is the problem here. Daniel Rashbaum decided that the prudent thing to do, and I will say it as a side, if he'd been prudent before, we never would have gotten in this situation. But the prudent thing to do is to get another waiver from Charlie Adelson. In the meantime, Judge Everett is pondering what to do, because it's one thing for Donna to say she waives her right to have an effective cross-examination of Charlie. It's another thing for the judge to say that he'll let her do it. She's got a Sixth Amendment right to a lawyer of her choice, but the people of the state of Florida have the right to assure that she's getting a fair trial. And at some point, what she would like to do may be overridden by what the judge thinks has to be done. Her inclination cannot control. So let's go to the next clip, and I believe it's clip 4, where we'll find that all this angst was moot.
almost scared to speak. Does anyone have anything to raise before we continue forward?
Yes, Judge. May I approach the lectern?
You may.
This is Roshbaum now.
So, Judge, with the surprise issues of the last couple of days, I have asked for my prior client's waiver again, and with the change of circumstances, he has decided not to give it. So let me be clear, I have a waiver in the past. It's from December 12th, December 13th, and an independent lawyer spoke to him as well, although did not get a signature on the waiver. So we had a waiver. We thought we had a waiver. We didn't think there was an issue. But given the events of the last 2 days, I approached appellate counsel to get a new waiver. Thought that was the right thing to do, obviously, and the cleanest thing to do. And I am not able to obtain that waiver at this point. So as a result, I need to withdraw from the case.
Very well. Does the state wish to be heard concerning the withdrawal of counsel?
I don't think I have anything appropriate to say on the matter, Judge. If Your Honor,
Well
that's what
put.
we need to do. We would like to proceed, and I'd ask Your Honor to inquire whether we can proceed with second chair representing Ms. Adelson, but obviously we're ready for trial and there's a lot at stake.
Mr. Morris.
Okay, you can tell how unhappy the prosecutor is here, but at this point, it really is unwise for her to press forward, to press that the trial should go forward. This thing had to end right here. What happens next is that Judge Everett talks to Alex Morris, as I said earlier, to see if really there was a wall and he had no information whatsoever about what Daniel Roshbaum's representation of Charlie was, what might have been said between the two of them, any of the evidence that was introduced, any of the testimony, any documents. He was completely walled off. And as I said, initially, Judge Everett thought that would be enough. But then a few days later, in a written order, he said he had looked at some case law, he had reconsidered, and the risk was just too great, that Alex Morris could not continue with representation. The independent third lawyer, Commissar, couldn't continue with representation. Donna would have to employ an entire new set of lawyers to go forward in the case. And that was going to delay the trial for clearly several months. The trial was delayed from September in 2023 to August in 2024, while the new lawyers got up to speed. Judge Everett in that order said, be sure that no documents, no anything is turned over to the new lawyers that have any kind of notes on them from Morris or Roshbaum, because then the new lawyers would be tainted also. So you've got to be clear that anything they get is completely independent of any of the work that Alec Morris or Daniel Roshbaum did on the case. Meanwhile, in his order, Judge Everett said that Daniel Roshbaum engaged, quote, in a conflicted representation falling short of the ethical obligations for a member of the Florida bar. I don't know whether Judge Everett actually filed a complaint against Roshbaum with the bar. I know that there was at least one individual in Tallahassee who did. We will not know the result of that investigation unless indeed the bar decides that Daniel Roshbaum did commit an ethical violation, and then we'll see something about it. Otherwise, not. So here we are. Where goes Charlie? Charlie, as I said, is going to file that collateral motion as soon as his appeals are done. He has no claim regarding a problem that occurred in Donna's trial because Donna's trial never went anywhere. So his claim is not going to be that his right to an effective lawyer, a conflict-free lawyer, was affected by anything that Roshbaum did for Donna. Charlie's trial was over. So nothing that happens after that could have affected the representation. But the claim is that his own trial was affected by Rashbaum's conflict. Now, there are two things that go on here. The issue is, did Rashbaum do anything at Charlie's trial or not do anything at Charlie's trial because he anticipated that the next thing up was that he was going to represent Donna, and that's where the conflict would be. He anticipated the representation of Donna, and did that affect anything at trial? Now, often with a serious conflict of interest, what the courts say is, the defendant doesn't have to prove anything, because how would you go about proving that your lawyer was affected by the prior representation? It's pretty hard to do. So we're going to presume if the conflict is serious enough that it had to have affected it. And if you can show the serious conflict, you're done. That's one piece of what Charlie's collateral attack will focus on. The other thing is, there was something that happened at Charlie's trial, and that is that Donna and Harvey were on Charlie's witness list, and then Daniel Rashbaum removed them. And the argument presumably is going to be that he removed them because he knew he would be representing Donna later. And this is a clear indication, not of presuming the conflict, but this is one where you can show the conflict. So I want to look at that a little, because to put what happened there in context, we have to go back to Daniel Rashbaum's great, I'm being ironic, understand, great secret defense that he didn't want the prosecution to know about. So what the sequence of events was here was that Georgia Kappelman, relatively close to when the trial was to start, listed Donna and Harvey on the state's witness list. At the point at which Daniel Rashbaum saw them listed on the state's witness list, he decided that what she was up to was she wanted to depose both Harvey and Donna. And depose is you do an interview under oath, and it can be used in court, actually, but you can also use it, to impeach witnesses, to show, hey, you said this in the deposition, now you're saying something different here. And that why she wanted to do that was she knew that he had some sort of defense, and she figured she could get it if she deposed Harvey and Donna, because they would know about it, and therefore she would pierce this defense that he wanted to keep secret from her. Georgia says, I wanted to, I didn't know whether the defense might call them, and I wanted to find out what they might say if they testified, and I had a right to prepare, and so I put them on my witness list for that reason. Well, what Daniel Rashbaum does is, when he sees Donna and Harvey on the state's witness list, then he adds them to the defense witness list. He says he has no intent to call them, but he was doing it as a defensive measure because of what he thought the prosecutor was up to. Now, frankly, I don't know how putting them on his witness list helps here, but he said this in open court prior to the conflict of interest issue erupting on the day Donna's trial was to start, with no inclination that we know of that there was any problem about it, that anybody was worried about it. He said it before, that had no interest in calling them. He only did it because they appeared on the state's witness list. Now, if the state had actually called them, they would have gotten immunity because it would have been a subpoena. It's like Wendy before, if you get immunity, you're being compelled to testify, and the Fifth Amendment protects you from being compelled to say anything that would incriminate you. So they would get the same sort of immunity. There then was a discussion at a hearing in which Donna's first lawyer Maricel Descalzo. She had been representing Donna and Harvey. She was at the hearing because the state went to the judge and said, they are declining to submit to my subpoena to be interviewed, to be deposed, because they're raising a Fifth Amendment privilege. We're giving them use derivative use immunity that has to attach because they may testify, and they're still being recalcitrant. So Maricel Descalzo now is before the judge and saying, well, her clients would be willing to testify to some. I don't recall exactly what the conditions were under which they would submit to questions. I tried to find the tape of the hearing, and it's unavailable now, so I couldn't confirm exactly what was going on. But in any event, Judge Everett says to her, they have immunity. They have an absolute obligation to testify, and you either get them here to be deposed on the date that the state has set for being deposed, or I'm going to hold them in contempt of court and issue a bench warrant, at which point Descalzo says they'll be here. Then what happens is, because remember, the state would only have called them as rebuttal and wasn't sure they would do it anyway. And who knows, it didn't appear that they'd say anything that was going to help the state. Daniel Rashbaum says, look, if you agree to remove them from your witness list, we'll remove them from the defense witness list. They agree to do that. And then I'm going to put up slide 2 now. There's a stipulation. Okay. And I cannot read that. I don't know if you all can read it. If you're seeing it on TV, you can. But here it's pretty hard to see. And I don't know if there's a way that we can enlarge this at all. But it's essentially that now it's taken away, so I can't even try to read it to you. But it's essentially a statement of the agreement between Georgia Kappelman for the prosecution and the defense. And then there's another part of that stipulation, if we can pull it back up, where you'll see Charlie signing off on it. You'll see a signature. Not that. It is the next page, but it may be a separate slide. There you go. There you go. And this one we can read. Here's Charlie saying he knowingly and intentionally is waiving his rights under the United States Constitution. That would be the Sixth Amendment, right to a lawyer. The Florida Constitution, any statutory or evidence rule, or pursuant to the court's discretion or other source, to call Harvey or Donna as witnesses in this cause, including during my case in chief or in rebuttal. So this is Charlie on the record in front of the judge, submitting a statement that he signed, now it's in writing, that he waives any claim that there's a Sixth Amendment problem, an effective assistance of counsel problem, related to any conflict of interest that is coming out of the fact that the defense has decided to call neither Donna nor Harvey. Now that looks like it takes care of Charlie's end of the conflict issue. What's lurking is what I said earlier. If the appellate court or would be the trial court again on the collateral attack would determine that this conflict was so substantial that Charlie doesn't have to prove anything, any actual place where the conflict affected the representation, the court would just presume it had to because the conflict was so substantial. I don't think it was, but that we won't know until after Charlie's appeals and after he files the collateral attack motion. And with collateral attack, I will add here that he would start in state court. And if he wins there, then, there'll be a new trial. And it has to be a new trial of everything because the taint of the representation, the conflicted representation affects everything at the trial. If he loses there, he has the right to file another collateral attack in federal court. There it's called a writ of habeas corpus. Habeas corpus means bring me the body. and the underlying claim under that is I'm being held in an unconstitutional way. And Charlie's claim is I'm being held in an unconstitutional way because my trial and my conviction violated my Sixth Amendment rights because my lawyer had a conflict. So it may go from state collateral attack over to federal court, another collateral attack. And not to make you nervous or make you unhappy about this, but he would then, if he lost at the trial level, he would have a right to go to the Circuit Court of Appeals, and then theoretically to get the Supreme Court to look. That will never happen. But he might also be able to go to the Circuit Court of Appeals. So his level of running with this is going to go for a while after, as I fully believe, his conviction will be reversed on appeal. That takes care of Charlie. Now we have to look back at Donna. She's got a claim out of the same facts. Now her claim is different. She can't claim that the conflict of interest affected her trial because Daniel Rashbaum never represented her at trial. You got a whole new set of lawyers. They started from scratch. Everything was done all over again. She doesn't have that claim. What her claim is that she was deprived of the right to have a lawyer of her choice under the Sixth Amendment. Now, at this point, it can't be Daniel Rashbaum. He withdrew. The judge didn't throw him off the case. He withdrew because of his problem with Charlie not being willing to either give him a waiver or reaffirm the waiver, depending on who you believe as to the existence of the original waiver. Her claim has to be she was deprived of a Sixth Amendment right to a lawyer, but her deprivation is Alex Morris, not Daniel Rashbaum, because Daniel Rashbaum is out because of the conflict. So that's where she is. Now, with regard to her, you have a right, if you're paying, to pick the lawyer of your choice. If you're being paid for, if the state is covering your bills, you don't have a right to choose. You're entitled to a competent lawyer, but you're not entitled to choose whoever you want. But if you're paying, you have a right to pick the lawyer of your choice. She says it's now Alex Morris. The right is not absolute. The judge is going to decide whether there was a substantial reason, and the appellate court, same thing, substantial reason for her not having the lawyer of her choice. The judge has a right to look to the administration of justice and to the fair and orderly proceedings in his court. And had she gone to trial with lawyers who might have been tainted, and in any event, a cross-examination that was going to have to be limited, that might well have been reversed on appeal. So I don't think she's got a claim here at all, but that's where her claim would be going. And I would say that Judge Everett said at the end of this hearing, when Donna's trial had to be moved to the next year, that the costs of all of this were going to have to be paid by Donna, because this was the problem is charged to her, and so the payment is charged to her. So taxpayers of Florida should be at least a little happy about that. You know, the witnesses that had to come in, they had moved people from the prisons to come testify. All of that had to be done again, and that's not a good situation for everybody, but that's where we got in this. So I think Charlie may have a claim. I don't think he will prevail on collateral attack. Donna, I do not believe, has a claim in all this, but she, I think, will raise it. Same thing, she may have to do it on collateral attack, not on the direct appeal, for the same reason. So this was really complicated, and I would love you to let me know how I did, and you can send a grade. If you have any questions, you can ask me on askprofjo@gmail.com, which is going across that, what I would call a ribbon right now. You can subscribe in YouTube. I'd love for you to do that. Hit like if you like this. And you can follow me on Prof Jo Explains, that Facebook group. And in addition, you can always become a member of my Patreon page, where we're going to be doing some exclusive content where I'll go more deeply into some issues. We'll be able to have via Zoom, face-to-face, actual conversations, not writing things down, and ad-free, which is a great thing to do. I love ad-free. If I could live my life with ad-free, I would do it. So I want to end again with a pet peeve for today. And my pet peeve for today is something just happened earlier today, but it's happened to me many times before, which is why it's been elevated by me to a pet peeve. You know those dispensers, it's got a little thing on the top and then something comes over and lotion comes out here. It's hand lotion. It's sometimes it's hand soap. It could be detergent, dish detergent. I don't know. It happens that there's several things that might be that. Sometimes it's, I think, even hairspray that has the thing. Well, I can't figure out how to open them. I do not know why they don't give you an instruction sheet where these things are, because I do everything. You have to turn it or something so that piece comes up, and then you can push it. And when you push it, the lotion comes out or the soap comes out. I have to have somebody come and do it for me. Now, you might ask why I don't buy some other kind of lotion, but I like it when it comes this way. And for hand soap, I like it when it comes out foamy. So I like it. I just don't like these things, and they're my pet peeve today. So with that, ciao, everybody. Ciao a tutti. And certainly ciao to proffers who are here. Love that you were here. So long.